Okay, let's get started. Well, first of all, welcome. This is the a Law to Think About webinar from BoyarMiller. Some of you may have attended our A Law to Think About lunch presentations last year before COVID-19 that were done in our office. This is our effort to continue those. These are a series of presentations that we put together that are geared towards business owners and entrepreneurs. And so we have a group on this webinar today that includes clients, it includes folks that are relationships with us, folks that maybe are getting to know BoyarMiller for the first time. And so welcome to all of you. Thank you for making time this morning. My name is Matt Veech. I'm a shareholder in our litigation group. My practice is, if I were to describe it in a way, I'd say it's employment centric. I represent, as it relates to what we're talking about today, employers dealing with employment law related issues, human resources related issues, from hiring and firing, policy development, pay considerations, terminations, investigations. And so recently, as in 2020, I've been dealing with a lot of COVID-19 related issues facing employers. When I'm not doing that, I handle litigation of all sorts, commercial, litigation, contract litigation, employment litigation. But as it relates to today, it's really, I think the unique thing I bring is some background dealing with and helping clients navigate this COVID world. So with that, I'll turn over to Whitney. Whitney, if you want to give a quick introduction.
Sure, yeah. My name is Whitney Brieck. I'm a shareholder in the litigation section with Matt at BoyarMiller. I handle general commercial litigation and appellate work. So any kind of contract or other business dispute, that's my specialty. I think when it comes to COVID, a lot of the things that we've been handling though are less litigation, more just managing complex business disputes. There are a lot of uncertainties that COVID has raised concerning people's performance under contracts and trying to manage customer relationships if you had to cancel contracts with customers, figure out refunds and that kind of situation. It's more dispute management and resolution rather than active litigation, but we do that as well.
All right, so what are we going to cover today? When we started putting this presentation together, we kind of looked at what are we being asked by our clients? What are we reading in the news? What are we hearing? What can we share with a group of business owners, entrepreneurs, and that might be of interest to them, might be helpful, and that from which they can maybe take away something useful. So I think there's going to be several parts of what we cover. We're going to start by talking about some of the background, what I describe as duties, obligations, responsibilities of employers and premises owners, and basically how those responsibilities and obligations are relevant in this COVID world. We're then going to talk to you about reopening your office, returning to the workspace, or as I like to kind of refer to it now, since a lot of us have returned and have reopened, is keeping the office and the workspace opened. We'll talk about liability waivers. We're getting, as Whitney sort of mentioned when she was introducing herself, we're getting questions about liability waivers. So we're going to share some information on liability waivers. We'll transition, talk a little bit about considerations for at-home work, remote work. Why does that apply in the context of a webinar geared towards reopening your office? It applies because it's a reality. It's not going away. We're going to continue to have, employers are going to continue to have employees working remotely. And so we're going to talk about that and considerations you need to be thinking about, even if you have everyone back to the office, things to be thinking about as you start having folks remote working again. And then lastly, one of the things we're asked about, and we thought would be very helpful, is kind of give you an update on what we're seeing, reading about as far as legislative activity relative to COVID, and what we're seeing initially in some of the early court cases to either one, inform you of things you need to be thinking about, or two, and potentially most importantly, dissuade you of some of the things you're hearing that maybe are causing unfounded, unnecessary fear of what COVID litigation might look like for a business owner. So with that, I'll turn it back over to Whitney. And Whitney, maybe go through, if you could, give us some of the background on general obligations of individuals, employers, premises owners relative to and how that kind of ties to or relative to the COVID pandemic we find ourselves in.
Sure. And I think it helps, with COVID, there are so many uncertainties concerning the virus itself, how it spreads, how sick you might get. There's a lot of worry about the personal injury aspect of it. As a business owner, what liability you may have on that front to your employees or to people coming into your business. And I think it helps to draw things back down to what just the basic negligence duties are in Texas law, because that would be the starting point. COVID is new, those things are not. So if you look first to the duties that individuals owe to one another from a negligence standpoint, or employers or premises owners, I think that helps kind of guide your conduct even in uncertainty dealing with COVID. For individuals, we don't really have duties that we owe to one another other than you have to exercise reasonable care to avoid foreseeable risk of injury to others. So in other words, you can't negligently create a situation and then do nothing about it if it becomes apparent that others could be injured by it. So that could be as simple as you knowing that you are COVID positive and being aware that you have certain duties to other people if that could expose them. For an employer, of course, this is not an exhaustive list, but has a duty to provide a reasonably safe workplace, establish rules for employee safety, warn people in that workplace of any unknown hazards. Also have to, make sure that any independent contractors are aware of those rules, abiding by those rules, or terminating contracts for people that would otherwise expose your employees. And then for premises owners, you really have a duty to, for people that are coming onto the property to transact business with you, to make safe or warn about any dangerous conditions or dangerous conditions that you know about or maybe even should know about, but the visitor may not be. So those are the guiding principles that should inform your decision making going forward. And I think there are just some general practical things that you can do or keep in mind as you're navigating those uncertainties. One, if you have a duty to warn other people about the possible risks in your particular building or workplace, there's something unique about how you guys operate that could increase the risk of contracting COVID, even with social distancing efforts in place. Make people aware of that. Post notices, explain what the special circumstances are so that there's no question that somebody coming onto that property is aware of those risks and assumes them. Uniformity may be key when it comes to your employees, making sure that everybody is able to stay sufficiently safe. And Matt will talk about this a little bit more in detail, but OSHA guidelines, CDC guidelines, I think it would be difficult for someone to argue that if you're really trying to stick to what the recommended protocols are or procedures, that you're not doing everything you can to make your space safe for other people to come there. And of course, everything's going to be situation specific. So get the right advice for whatever your particular concern may be, because all of this is evolving. And as new regulations come down or as new things are become known about the virus, you really do need to be consulting with people to make sure you're taking adequate steps to protect your business and yourself. I mean, all of the legal challenges on the personal injury front are going to pretty much come down to what a reasonable person in your shoes would do. And so that applies with COVID and anything else. One of the primary things to consider planning for in advance is, what are you going to share with other people if you find out you have an active case on your property, or if there's a possible risk of exposure to other people? How do you share that information? How far do you disseminate it? Troubleshoot those things in advance so that you can satisfy that standard of what a reasonable person would be doing. But be aware that anybody who's bringing a personal injury claim against you for having contracted COVID or gotten seriously sick with COVID, they've got more than one pretty challenging legal obstacle to overcome, just to even show that they, one, caught it at your facility, and that, two, there wasn't some other contributing factor that made them more sick than anybody else might have been. And so it's not necessarily, even if you do have someone who brings a personal injury claim against you related to COVID, it's not a slam dunk case, but that doesn't prevent you, of course, from ending up in litigation over it. So that covers kind of the general duties. Matt, can you share a little bit with us about what employers have been doing or should be doing to reopen with those duties in mind?
Sure. So pick up on what Whitney mentioned. It's kind of a couple fold. First of all, be familiar with the CDC's current guidance on reopening. It's not too current in this world. I mean, it's been out now for a couple of months and hasn't necessarily been updated much. So it's out there. I think it's pretty well known. Be familiar with OSHA's reopening guidelines, and be familiar with any local city ordinances, state laws, local ordinances and regulations that are going to govern you. Obviously, for most people on this call, we've heard about the different things Harris County has issued. So these are all, in the context of reopening, all the things you need to stay on top of. So what are these things? It's many of the things you've heard about. It's social distancing. It's ensuring proper hygiene. It's making sure you're providing the appropriate personal protective equipment for your people. Those things are mandated by CDC rules. They're mandated by OSHA. And so there are things that as a responsible employer, you need to be doing. What are the other things you need to do to reopen and stay reopened? Make sure you're handling sick employees appropriately. This is going to become even more important in the coming months as we face the dark winter, if we do in fact face a dark winter. Either way, we all know we're going to have flu. We're going to have more cases of COVID. So handling sick employees, what do we need to do as an employer? Revisit your sick leave policies. Most employers, most companies have sick leave policies that provide things like in order to return to work after being out, you have to have, for a certain number of days, you have to have a doctor's note. Well, that's a policy that in the context of COVID, we're going to have to relax, because the guidance from our authority, CDC and others, is do not require this doctor's note of your employees coming back from a COVID-related absence. Employers are going to have policies that talk about no call, no show. That's the policy where if you don't show up for work and you don't call in and let us know you're not coming in, you're going to be fired. That's a policy that you as an employer may have to, case by case, consider relaxing your uniform enforcement of that, because if it's a COVID-19 related situation, I can't see how somebody wouldn't be able to call in and let their employer know, hey, I'm experiencing sickness symptoms. But we want to be careful that we're not acting too quickly. Continuous absence policies. This is one that I've started to actually have a few clients deal with this, where employees are out for extended leave because of COVID-19 related illness, or COVID-19 either related, should say, symptoms. And so if you're an employer and you have a policy that says you will be terminated if you're absent from work for X number of, after the expiration of X number of days, whether it be 90 or 120 days, in this COVID pandemic world, that's another policy that may have to be relaxed. Obviously, the other thing, to stay reopened, you as an employer need to make sure you're engaged in normal and routine cleaning. Lots of information on that on the CDC's website. They also reference very informative information on the EPA website. The other things to think about are what I call the workplace adjustments related to your people. Is there a way that you can have phased returns of people, or if people have already returned, that they work in phased or stages, alternating shifts? Is there a way that certain group of people only are working earlier in the day and others are working middle of the day and later in the day? All of those are measures to control density that allows us to promote social distance. social distancing. Why do you want to do those things? You want to do those things because a couple of fold. One is it's the right thing to do to prevent an outbreak, just like wearing a mask is the right thing to do to help control outbreaks. Secondly, you arguably are obligated to do those things in order to provide a safe workplace as mandated by OSHA. And so, you're doing it twofold. You're doing it it's the right thing to do to promote health and safety and well-being of your employees. Secondly, to control potential liabilities. The other issue is workplace or workspace adjustments. So you got adjustments relative to your people, what schedule, so forth, are they going to be working? What are you going to change as far as the layout of your facility, whether it be an office, whether it be a warehouse, whether it be an active manufacturing facility? There's things you should be engaged in looking at and determining, is there things you can do to adjust a workplace to promote social distancing, to promote PPE or other ways of protecting workers from each other, and promoting proper hygiene. The interesting thing that I think we're going to see develop is the employer's obligation to provide hands-free control technology things. What do I mean by that? In so many workspaces, there's things we have to do that are done by touch, or that necessarily are going to create high touch areas. And those things can be modified to where you no longer need to touch, and it can be done by voice control. And so I can see us moving towards more and more of routine functions in the workspace needing to be done by voice control or artificial intelligence as that becomes more mainstream, and away from creating these high touch point situations. Not mandated yet. No, not mandated. Just it's the direction we're going. But again, if we're required as an employer to provide a safe workspace, I could see where not addressing a situation that creates high touch points is creating a situation where you're not providing a safe workspace. And then last thing on this kind of adjustments to workspace would be environmental controls. I'm not saying we need to go retrofit your workspace with the fancy UV lighting that supposedly kills this virus, but ventilation issues. Are there ways to promote better ventilation within your space? That would be an easy, logical fix. So those are things that I think, Whitney, that our clients are dealing with right now, putting in place, or at least evaluating putting in place. The other thing, I know you've mentioned it, and I know we're being asked, and I'm going to ask you to talk about, is liability waivers. What do our folks on this call need to know about what liability waivers? And before you answer that, let me just, everyone, all the participants on the call, don't forget there is the chat feature. So if there's something we don't bring up that you're interested in hearing, please put it in the chat feature. We have seen a question or two, so we'll handle those as they fit into our presentation. But Whitney, liability waivers, what do we need to know?
Yeah, so I think a lot of people are considering this as a possible means to limit their liability for COVID exposures or other business interruptions related to COVID. Generally speaking, it's a contract, so it's going to be governed by default contract law in the state of Texas or wherever else you're conducting business. In Texas, we of course have a strongly held, longstanding freedom of contract public policy preference, and so to the extent possible, those waivers will be enforced. But there are some considerations for how that gets done. They just seek to allocate risk by agreement. They're generally enforceable with some specific limitations. For example, as a matter of law, you're not able to disclaim liability for deceptive trade practices. Sometimes you can't disclaim liability for gross negligence. And when it comes to a pre-injury waiver of liability, so you're preemptively waiving someone's potential future injury claim related to COVID, catching it on your premises or in your workplace, that type of risk shifting is considered in Texas to be extraordinary. And so it has to satisfy two main requirements for just what is contained in the written document. And it's called fair notice. So it has to have express intent of with specific terms about what you're disclaiming liability for, so that there's no question on whoever's is signing that they understand completely what rights they're giving up when it comes to a future injury of theirs. And it also has to be, of course, conspicuous language, so it's not something that's just buried in another contract that they might have skimmed over and missed. Of course, if somebody has actual knowledge of what they're releasing, that's different, but those are the two primary written requirements. But those are just the written requirements. The courts will also look to, is there some type of disparate bargaining power between the two people entering into that type of contract. A very obvious one might be an employer and employee relationship. If, especially during times of a pandemic, somebody's just trying to earn a living and is forced to sign one of these waivers in order to come to work, a court might consider that to be such unequal bargaining power that they would invalidate that liability waiver. And it also can't be contrary to public interest, public policy. And I think it's entirely likely that protecting people from COVID and ensuring people who are employers or running facilities are taking the reasonable steps to protect people, that might be a public policy reason why this type of broad release might not be enforceable. An example of when courts have invalidated that type of release would be just in the general employee relationship context. So an employer can't, as a matter of law, get a general release from employees for all future injuries caused by that employer's negligence. A public utilities company, for example, if they're performing public service, can't get a release of future injury for its negligence in performing those public services. So I think there is a real concern that if you are using one of these waivers to guard against your future liabilities, that it might not in fact be enforceable if it comes to that. But that's not to say that it doesn't have value and that it could still protect you depending on how it's drafted. It certainly does, going back to those duties that you may owe to make people aware of the risk. It certainly puts someone on notice of the risk of catching COVID or being more exposed in your particular environment than they would be otherwise with social distancing. So that's a valid consideration. But do be aware, there are certain states where they're never going to be enforceable. Louisiana, Virginia, Montana, they're not going to enforce a pre-injury future waiver of liability that I'm aware of. And I think you also have to keep in mind immunity from liability, even if you're right and the limitation is enforceable, that doesn't keep you from getting sued. So you have to manage that risk in addition to the risk of damages at the end of a lawsuit. So that's all in the personal injury context. I'll say too that there are limitations of liability in just general commercial contracts, whether it's travel companies who have an exclusion for damages in the event of a pandemic that they're now trying to enforce. Those courts, as far as I can see, are in fact enforcing those. There was a case up in Maine with college refunds. There was a group of students who wanted a refund for tuition that they paid for services that they weren't getting because of closures under COVID. And the court enforced the contractual waiver for those types of damages or that type of refund because it fell within one of the exclusions of the contract for pandemic-related inability to provide services. So it entirely depends on the context. It depends on the state. It depends on how you draft it. It is a valid thing to look at if you're trying to limit your liability as a business owner and employer, but be aware that there are pitfalls too. It's not a perfect shield. So with that in mind, and knowing that these waivers can be a challenge, Matt, do you have recommendations for employers dealing with employees returning to work and some that are continuing to work remote?
Yes, I mean, that's one of the things we're constantly helping and trying to advise clients on how to deal with this issue. We actually had a question come in about, in the context of having employees come back to work, can the employer mandate that the employee be vaccinated with the COVID vaccine when and if that vaccine becomes available? And the answer, I believe, to that question under what the EEOC's guidance has been is yes, except if the employer, except unless the employee can object on religious grounds. Employers are obligated to provide religious accommodation just like they're required to provide accommodations for individuals with disabilities. And so if there is a I forget exactly, the legitimate religious belief basis to object, then the employer may not be able to mandate the vaccine. The standard, however, for religious accommodation in this context is if the accommodation would cause anything more than a de minimis effect or disruption to the employer does not have to provide the accommodations. There, I see that there could be a very good argument in this context for the employer to say, look, this creates more than a de minimis disruption or more than a de minimis effect on us as an employer, because by not getting the vaccine, is the employee creating a direct threat to themselves or others in the workplace. So that's how that's going to play out. That's going to, without a doubt, that will be in the courts, where an employee for religious grounds, religious reasons, refuses the vaccine, gets fired, sues for religious discrimination. It makes its way to the courts, and we'll all know that answer years from now. Nobody will know today. And so that's the answer to that. Back to what employers can be doing, knowing that they can't ask for liability waivers. Relative to liability waivers, another point to make for anybody who is on this webinar who's a workers' comp subscriber employer, under the workers' comp laws in Texas, pre-injury waivers are void. So they are no good in this context. That's assuming that the COVID becomes a workplace occupational injury. But my advice to employers has been, don't ask for them because they're not effective pre-injury waivers. What are some things, though, that employers should be doing in addition to what we've already talked about? Create some procedures, or have a policy, have something out there that provides employees with notice of how they raise concerns or questions. The OSHA and CDC have both issued statements, or within their guidance, there are statements that I say put a burden on an employer to make sure that the employer has created an environment that promotes clear communication from the employer to the employee of how we are handling COVID, and a procedure in place that allows for communication from the employee back to the employer about that employee's concerns. Again, why is that important? It's important because, again, OSHA dictates that we provide a safe workspace. And so we want to have employees to feel comfortable when that they have an avenue to raise complaints. Within OSHA's guidance, they actually say that having clear communication promotes employee confidence and the employer's ability to protect its workers. So I read that, and it makes me conclude that as these cases work their way through our system, where employees are complaining about an unsafe workplace under OSHA, that one of the things OSHA is going to say is, okay, employer, that's great. You are providing the PPE you should provide. Did you have in place a complaint procedure? Because that's one way that you promote the employee's comfort, that the employee's confidence that their well-being is protected. So within whatever you put out, you want to have a way to say, if you have any questions, come forward and talk to John or Sally. Employers should make sure they're complying with the mandated postings. Most of us probably realize this as employers, but as part of the CARES Act and the original Families First Coronavirus Relief Act that passed back in March, April, there were certain federally mandated posters that employers had to post in break rooms relative to the new rights of employees under those laws, similar to your minimum wage postings and workers' comp postings. So you need to make sure you're doing that. In addition to having a clear message of how we communicate, it may be, depending on the size of your company, a good investment to have some sort of internal web page where employees can go and get the latest on what the employer's policies are, what their procedures are, what their recommendations, what their guidance is relative to the COVID pandemic. It's basically creating a place where we're going to be transparent, we're going to be open, and we're going to be informing employees of what's going on. Training. OSHA looks to, and CDC has statements that say, make sure you're training on these appropriate measures that you're putting in place to protect against spread. Make sure you're training your people. The last point I think that employers should be aware of as it relates to creating procedures and policies to promote communication and to promote transparency is to be mindful of something we forget about here in Texas all the time, which is the National Labor Relations Act and its application to the employment context. And here it is, and here's how I see it potentially coming up for our employers. The National Labor Relations Act typically applies to companies that are union. It's a union protection law allowing labor to collectively bargain and unionize. However, those protections have been extended to non-union workplaces. And so as it relates to the issue we're presented with is employees are allowed to communicate, join together, and raise concerns when the purpose of it is for their, quote, mutual aid and protection, okay? Typically what we've seen, at least in my practice before COVID, was employees coming together to raise concerns about their pay or to raise concerns about the number of hours they're having to work. Something along those lines, which is all protected activity. Employers cannot take action. They can't prohibit it, and they can't take action against the employees for engaging in it. So we can all imagine relative to the COVID and the concerns it raises for one's safety, benefit, well-being, that when employees are talking about that, when they're joining together, when they're coming forward to management, you can't, as an employer, retaliate against them, and you can't, on the front end, prohibit that sort of behavior. So I'm anticipating we're going to see more and more of those types of cases coming forward as employers maybe misstep and employers put in place either one, disincentives for employees to come forward, or have outright prohibitions against employees meeting to discuss the company's COVID-19 policies, or taking action against employees when they raise COVID-19 concerns. When an employee or a group of employees are complaining about lack of adequate PPE and some sort of action is taken against them, that's going to potentially give rise. Think about it in the context of, earlier I said employers should look at alternating work schedules. If you have employees who are raising grievances about work schedules or the number of people they're being forced to work with, again, that is communication for their mutual aid and protection. So there are going to be a number of ways in which employees are engaging in what is considered protected activity under the National Labor Relations Act, and employers cannot prohibit it and certainly cannot take retaliatory action against employees for engaging in that sort of behavior. So that's one where we want to really be mindful. Whitney, what are we seeing in the courts, in the state legislatures and so forth? What kind of activity are we seeing?
Yeah, for legislation and litigation, there's actually a pretty good question that I can read that relates to this topic. It says, do you anticipate significant differences in how the country, states, counties handled COVID in 2021, depending on who wins the election, shutdowns, mass mandates, et cetera? less related to mask mandates, but COVID liabilities and protections for either businesses or the labor force. Yes, I think there will be dramatic differences depending on what happens in state legislatures, governor seats, federal politics as well. And that's because states have been very active, governors have been very active, and even federal legislation has been proposed at least that would affect some of the COVID liabilities that we've been talking about today. The federal legislation has not gone anywhere. It was part of the negotiations for other COVID relief actions, and so it's died on the vine with everything else. But John Cornyn did co-propose with Mitch McConnell a Safe to Work Act that would have provided schools, businesses, and hospitals with pretty significant liability shields for COVID-related illnesses. I haven't read studied the text of the bill in great detail, but a lot of commentary has suggested that it would have been a pretty high burden for a claimant if you wanted to sue someone for being exposed and getting sick in the workplace or in someone's school or hospital, that you would have had to essentially establish a gross negligence standard, that there was a pretty wanton, reckless disregard for a serious health consideration on the defendant's part in order to recover for whatever your personal injury may be. And I think a lot of people who are on the labor side of things were pretty critical of the bill for that reason. But it is no must, so we don't have to worry about that for now. But I do think that depending on what happens in the election, that could be something that comes back up again in the future. For the state legislation, there were initially a group of states, New Jersey, New York, and a couple of others, that really focused on protecting healthcare providers, hospitals, PPE suppliers, volunteer workforce that was coming in to help support the medical teams that were dealing with the COVID fallout initially. Those states were pretty quick to enact protections for those specific industries so that they could take care of people without worrying about personal injury lawsuits as a result. Then there were an even larger group of states, Iowa, Georgia, Kansas, Louisiana, and a number of others that enacted state legislation to protect businesses specifically. Now, they all have varying circumstances in which you could avail yourself of those liability protections and governing standards for when somebody could overcome that liability protection. Virtually all of them have some kind of an exception for gross negligence, contrasted against that federal legislation that I mentioned, so that you do still have a duty at some point as a business or an employer or a school or a hospital, even if you do have some statutory protections. And I know at least of one state, I'm sure there are others. Michigan recently signed into law a couple different bills. One did provide some liability for businesses if they're following CDC guidelines or following OSHA guidelines. They're doing their best to try to stay on top of those to keep their workplaces reasonably safe. There may be some protections, but on the flip side, they did enact some specific anti-retaliation and other kind of labor protection statutes so that the workforce is protected equally. So it kind of balances those two interests, which I thought was interesting. And I want to share the screen for a minute because I do think this is an incredibly powerful tool that I found. If you're doing business outside of Texas and you want to find out, Matt, can you see my screen there?
Yes.
Okay. So this is the National Conference on State Legislatures. They've put together this really great tool that you can just hover over for any particular state, and it will show you the bills that have been proposed, passed, failed, signed into law, what have you, that relate to COVID. And so, for example, if you click on one state, it'll populate what the bills are. And so you can look through them. Not all of them are going to be COVID liability protection. Some just may be appropriations for COVID spending within the state. But you can find, I told Matt I wanted to look at this one. Where did it go? Alabama actually passed a joint Senate resolution to encourage fist bumps rather than handshakes. So there's some stuff that wouldn't necessarily pertain to your business operations there, but that is where you could find if there's a liability protection statute that you need to be aware of. That's a great place to look. So that's legislation. And there's also been, part of the rationale for the federal legislation that was proposed was that there was going to be this, waterfall of COVID litigation, that I don't know that it's actually proven true. I do know that there are people who are tracking how many actual COVID related cases are being filed, and it is in the thousands since all of this got started. So there's a lot of litigation, but it's not all necessarily personal injury litigation. We've talked about that a lot today, but it comes up in a lot of different contexts. So for the personal injury litigation, you have things like nursing homes, cruise lines, meat packing plants, and then inmate litigation, where people are complaining about, whatever the specific exposure circumstances were when these people were participating in, for example, staying on a cruise line, and then trying to create liability for them getting sick. But then there are also other permutations of COVID litigation, like the constitutional challenges that people have been raising against the stay-at-home orders or the business operation restrictions. I know in Texas, the bar associations have gotten together to challenge some of the requirements, restrictions against the bars operating in a certain manner or with a certain density in the state. And then you have, I know we all are familiar with kind of the election related, but also COVID related litigation. That you have challenging either certain election procedures the different counties are trying to put into place, or even like the convention center litigation that happened with the Houston Convention Center not wanting to host the Republicans in Texas, and the challenge on whether or not that contract it was essentially, I think, a force majeure clause. I don't know that that was how they described it, but allowed the convention center to back out, saying it wasn't safe for them to perform under that contract. And there was subsequent litigation both in the state courts and the federal courts over whether or not that event was going to take place. So a different type of COVID litigation than just your average personal injury lawsuit. And to that point, I mean, there's a lot of lawsuits being filed now that we don't know how they're going to turn out, but that are arguing over people's performance under contracts being excused either under a force majeure clause or the impossibility doctrine. If their performance requires you to be operational in your bar and you can't operate because of the state restrictions, whether or not you get excused from further performance. And then, as I mentioned earlier, refund cases for college tuition or travel, prepaid travel companies. Seeing how those contractual disputes play out will be interesting as well. And then Matt touched on there's some, anti-retaliation protections that will be litigated if somebody feels they're being discriminated against with respect to COVID, protections or compensation. And then if they report an unsafe condition, if they're being retaliated against, I think we'll see some of that as well. But I think that's the landscape as far as I can tell. Matt, any final takeaways from your clients? Do we have any other questions?
Yeah, I mean, I guess one thing that I failed to talk about, and I will briefly, is kind of with the reality that we're going to have people still working from home, either on a occasional basis or more permanent basis. I think there's things to be considering there. We also received a question about dealing with returning an employee to work after being out on COVID-related leave due to a COVID-19 diagnosis. And how do you deal with the situation if an employee continually tests positive? So here is my advice on that, and it's based on the way I read what the CDC has provided as far as guidance. And that is, in order to return somebody to work after a COVID-19 case or suspected case, originally the thought was a negative test versus or an appropriate quarantine period and then a certain number of days or hours of being symptom-free. What the CDC said is, well, you take a step back. What the CDC says is an employee can return to work once they've met the appropriate home quarantine isolation requirements. Okay, so then you say, okay, what does that mean? Well, what the CDC said was a test-based, I'm reading this from their website, a test-based strategy is no longer recommended to determine when to discontinue home isolation, except in certain circumstances. So what does that mean? That means that really employers, I think it's better not to have a policy that says after a COVID-19, after you're out for COVID-19, you have to provide us a negative test in order to return to work. Instead, they should follow what the CDC says as to when that person can discontinue home quarantine or home isolation, which is it's at least 24 hours have passed since the last fever without the use of fever reducing medications, and then no other symptoms. And I believe it's at least 10 days have passed. So it's really, you should be returning to people to work based upon a symptom-based approach, not a test-based approach, is the quick answer, short answer. And the reason for that is what the CDC says on home isolation. One other thing I would mention is the question about the vaccines. One thing I failed to mention is what's going to be interesting about that is who's going to pay for the vaccine. The question was asked about, can employers mandate it? And I think subject to or accepting those religious accommodation context, yes. However, who's going to pay for it? Not a whole lot of guidance. There's some things you can look at within the EEOC's guidance and their statements to maybe draw some conclusions, but I think that's going to be an area that develops. Finally, relative to, I wanted to talk about at home. So with people working at home, and this is something I've helped a number of employers with when COVID first started finding its way into our society, and that is things you need to think about. And that is protecting your company information. What do I mean? Well, you now are not having people do their job within the security of your workspace, your office, your facility, your platform, but they're now outside. They're in their home, on their internet, maybe on their own device doing work. So how are you going to make sure your information is kept and remains secure and is not misused or somebody hacks in and gets it? So as soon as COVID hit, we all kind of transitioned into these well, they existed, but seemed to be new platforms like Zoom for meetings, GoToMeeting, Zoom, the Microsoft Teams. There's many questions about the security of these platforms. And I know in dealing with certain of my clients, they won't conduct meaningful business via Zoom. They only want to do that on a more secure platform, which is believed to be something like Teams. So as we have at-home people who are remoting in and doing work that way, we're going to need to make sure we have secure platforms. Another big issue with the remote work folks is timekeeping and making sure your non-exempt hourly employees are appropriately, or salaried for that matter, but your non-exempt employees are appropriately paid for overtime, and that you as an employer are doing your required tracking and maintaining of time records. What's interesting about that is in late August, the DOL, which monitors and enforces our overtime laws and the Fair Labor Standards Act, they came out with what they titled their Field Assistance Bulletin, and it dealt with kind of giving some updated information on work remote, obligations of employers to make sure you're paying overtime, to make sure you're tracking time and maintaining records. And I didn't realize this until I'd read this, that it was the first update that they had provided around remote work since the interpretive rules were put out in 1961. So very outdated. But basically, employers have to pay for work that people are doing, even if it's work that you're not asking, even if it's for work that they have not been asked to do. There's a lot of policy development to be done as an employer to make sure you're, again, capturing and tracking the hours and paying people for those hours. Um, and lastly, relative to the work remote people, uh, are there going to be certain things that the employer is going to be obligated to provide to allow the employee to do their job from home? Are you going to have to provide a certain type of computer? What sorts of tools to do the job are you going to have to invest in order for the employee to be able to do their job remotely? There are existing rules that do not require the employer to pay for kind of miscellaneous office supplies, pens and paper that are necessary to do your job at home. However, there's not very much guidance on whether the employer has to pay for the employee to have a reliable internet connection, or their personal cell phone. If they're using their personal cell phone, now they're having to work remote. They don't have their desk phone. Do you need to pay for some part of their cell phone? These are all issues that are going to be faced by employers. We need to be proactively thinking about them. And the reason I say that is the CDC still promotes that where possible, employees should be working remotely. OSHA, in its guidance, still promotes and still directs employers where possible, employers should be working remotely. And lastly, the EEOC, in the context of accommodating folks with disabilities or other sorts of limitations, state that employers need to be evaluating work from home as an accommodation. So it's here, even as we reopen, even as we hopefully do things to stay open, we're going to have folks working from home. So I think that kind of covers it. I guess one last thing on the that I think is important for employers to know on testing of employees as you return them to work. Obviously, it's fine to do the screening of your employees, have them answer a questionnaire, the standard questionnaire that we've now all answered 1,000 times about, do you have any of these symptoms? Have you been to any of these places? Have you been in touch or in contact with anybody who's been diagnosed? That questionnaire, taking someone's temperature, that's all fine and well. I think that the area that we're going to see develop here is what do you as an employer do with all that information? Are you actually collecting it? There's something to be said for you shouldn't, because you don't want to now you don't want to hold all of this medical related information and take on the preservation and confidentiality aspects of it. So that's an area that folks like me are going to continue to deal with, is kind of how is the employer supposed to handle all this information we're gathering to ensure we're not bringing sick employees back to the workplace. And then lastly, relative to COVID testing, be mindful that the EEOC and the different agencies that enforce these laws look at the virus testing for the virus versus testing for the antibody differently. It is okay to test for the virus in the employment context. It's not okay to test for the antibody. And that is because the antibody doesn't really tell you about anybody being a direct threat, whereas the virus does. So there's all these subtle, nuanced areas of testing, of workplace alteration, people working remotely that we're going to continue to see and they're going to continue to develop. It looks like we had an additional question come in, Whitney, relative to whether we anticipate there will be more PPP relief, and has there been much guidance on PPP forgiveness? I will tell you, that's not my area. I can tell you that we have written, our partners have written a lot on PPE and the status of PPE and PPP forgiveness. I would recommend go to our website, BoyarMiller.com, and there's a COVID webpage, I believe, and you can find a lot of information on where the current status of PPP and PPP forgiveness. As far as whether there's going to be more money, I think that's one of those, your guess is as good as mine, considering that the folks in Washington can't agree on anything. So with that, unless you have anything to add, Whitney, I think we're kind of up against our window.
Yeah, no, that's very helpful information. I appreciate it.
All right. Well, since we can't really take Q&A because everybody's muted, I think that brings us to the end. And thank you for joining. I hope it was informative. And we don't have necessarily any written materials from this, but I believe we are recording it, and it will be available at some point on our website. And I would expect that Josie Morgan, who you, I think, received an email from, who is our Director of Marketing and Administration, she will probably send out a link to those who participated on this with a link to the video. So thank you for joining us, and look forward to having y'all back in our office sometime in the future for our next law to think about. Thanks.
Thank you.